So I'm very honored, you all, to introduce Colleen Byers, who's on the screen. Wave, Colleen, because I see you smiling. There you go. Colleen not only has her JD, but she has an MBA. She is the founding principal of Colleen Byers Mediation, LLC. Colleen works with multi-generational family businesses and families engaged in high conflict trusts and estate disputes. She helps them unlock horns and settle their disputes so they can find some peace. Colleen's conflict resolution approach weaves together practical business insight, active listening, and an interest-based negotiation strategy. Colleen is a neutral with Alterity ADR, a national panel of mediators and arbitrators committed to improving diversity in the field of conflict resolution. Colleen is triple certified by the North Carolina Dispute Resolution Commission to mediate Superior Court, family financial, and matters pending before the Clerk of Superior Court. In 2020, Colleen was named the Lawyer of the Year by North Carolina Lawyers Weekly. Colleen also serves as a professional development coach and consultant for lawyers and law firms. And folks, just to let you know, there are a lot of programs recently where people kind of skip over the bios because these people are so well known. I'm going to let you know, I'm going to bore you to death because I'm going to read everybody's bio because the speakers we have today are absolutely spectacular. And I think that they do deserve a few kudos, and they're doing this out of the kindness of their heart and because I begged them to speak for us today. And I also have shortened everybody's bio. So if you want the real gist, by all means, look them up on social media, their website. I'm sure it is all posted. So that being said, we've got 1 minute, and I think, Colleen, I've got you as a co-host, so you should be able to unmute yourself. I'm going to ask Colleen to go ahead and jump on and start this. Oh, wait, one last plug, I'm sorry. Just real quick again, if you all want a better view, on the top right hand of your screen, you'll see a box that says layout. Because we've got 300 people, if you want your speaker to show up nice and pretty in the middle of your screen, click on the layout button and then click on the middle button on the top line. It's called stack, and it will pop out whoever's making noise or talking. Hopefully, if you don't like that screen, by all means, change it around a little bit. We just wanted to give you all some options. So I'm going to turn it over to Colleen, and we're going to go ahead and get started.
Thank you, Tara. Good morning, everyone. I am going to share my PowerPoint. Okay. So I think I have now lost the ability to see the chats, but I know that Maureen is going to be fielding those. I am excited to be here. I'm honored to be here. I learn so much from this program every year that I attend. It is one of the best programs for both CLE, but particularly CME. So I am honored to be speaking to you. I think that I'm going to learn more from the other speakers than you all are going to learn from me, but I hope that this is valuable. And I've tried to make it interactive. I recognize that it's 9 o'clock and that we're all staring at little tiles on a screen. So I will try to make it interactive. I have some polls that Tara is going to help me with. So there's going to be a little bit of lag time on the polls, but that will give you time to engage your brain and pick an answer. Your answer, like, it gets aggregated. So don't worry about being shy about getting the wrong answer. Just pick an answer. Nobody's going to know if you got it wrong. So the theme that you saw from the agenda for today's entire program is getting back to the basics of communication. And so some of the things that I'm going to be talking about are the different ways and the different people that we interact with from a communication standpoint when we mediate. And because it's almost Halloween, and because I have young children who are obsessed with Halloween, I decided to make it a Halloween theme. So we're going to talk about trick or treat, handling spooky situations under the rules and standards. Let me see if I can get to my next slide. Okay. So I suspect that everyone knows this already, but because we're getting back to the basics, I would be remiss if I didn't remind everybody that the DRC's website, which you can access through the AOC website, has a mediator's toolbox. That toolbox is invaluable. It has every DRC program. It's organized by program. So if you just want Superior Court, you go to the Superior Court subcategory and you find all the rules and all the forms and all the things that go with Superior Court. If you just want Family Financial, it has that segregated. If you just want the rules to mediate before the clerk of court, for those of you who may not know, there is a separate certification process and separate rules for mediating matters before the clerk. Those tend to be special proceedings, estate and guardianship matters. And then I know I don't personally participate in the criminal program, but all the programs that the DRC administers have areas in the toolbox full of resources, and then also the standards of professional conduct are easily accessible. So I have this saved as a favorite in my browser to just instantly be able to get to the mediator's toolbox, and I would commend that to you. And then you can easily see the rules. They are great about updating, so any of the amendments that come through instantly get updated here as well. So this is one-stop shopping to find all of the rules and the forms and the standards of conduct. A reminder, because I found this tricky and confusing. The rules of each program only apply to those matters that have been ordered into mediation, or to which everyone voluntarily agrees the rules are going to apply. The standards of professional conduct for mediators always apply to us when we mediate, even if we are mediating an early matter, a voluntary matter, or a matter that otherwise does not fall within one of the DRC's programs. All right, so the first topic we're going to talk about is communicating with attorneys, parties, and non-participants. All right, so first sort of engaging question. I'm gonna throughout this presentation propose fact scenarios to help us think through the rules, and then we'll talk about the rules and the standards as they interplay. Please put questions in the chat. It is quite possible that I will not know the answer, but there are other people much smarter than me and more experienced on this program that can help us figure out the answer. So the first topic that often comes up, we get a matter in, maybe it's designated or maybe it's party selected, voluntary, and we have to think about conflicts and disclosures under the standards of professional conduct. Make sure, is there a conflict? And then if not, is there anything I need to disclose? So in this scenario, the mediator is asked to serve as a party selected mediator in A versus B and C. The lawyer for party B informs the mediator that party B apparently consulted with but never retained the mediator roughly 6 years ago about this dispute, but that everyone knows about it and will consent to the mediator serving as the mediator in this matter. May the mediator mediate this matter? And so Tara's gonna put a poll up. It's gonna take just a minute for her to do the magic tech that she has to do for that poll. So you're thinking through, is there a conflict under the standards? And the question is, may the mediator mediate the matter when the mediator consulted with but was never retained by one of the parties in the dispute? So go ahead and answer the poll.
And real quick, I want to remind everyone, your results are anonymous. Okay, so this is kind of for fun, just to kind of see where you all land. A lot of these scenarios are gray, which is fantastic. Colleen's got excellent examples for you guys. But at the end of the polling session, I'm going to display the results so Colleen can go over that. But when we are done with the question, you all need to click the little X box on the top right corner of the poll to make it go away so we can do future polls, okay? And then one more tiny little thing, sorry, housekeeping. If you are calling in, you need to make sure you email drcmediators@nccourts.org with your phone number and your name so we can give you CLE and CME credit. All right, I've only got 70 people out of 201 who've answered. So come on, people, pick an answer.
You have 50-50 shot.
And it's right now it's running. You guys can't see this yet because I've got the results back here, but it's close.
Someone said they can't get the box to check. So are you saying you can't see the poll?
All right, we're doing pretty good. I'm going to give it about 10 more seconds. I'm going to close the poll and put the results up for y'all.
So someone says they can see the box but can't check the answer.
I'm trying to close the poll, but people keep chatting and it keeps covering my closed poll option. Hang on, I'm working on it. I'm almost there. Oh, nope, somebody else put in a chat. All right, let me try. Gotta love technology, folks. Got it. Okay, it's giving me a 6-second countdown. So it can calculate all the responses. There we go. Okay, can you all see the results? Nod for me, someone.
Okay, so 88 of the 203 said yes. 73 of the 203 said no. Is that right?
That's right.
Okay.
Okay. I'm going to throw your screen back up.
Okay. Drum roll, please. No. Why not? Under Standard 7C, there is a conflict of interest. Under the mediation rules, conflicts are not waivable. There may be certain circumstances under our ethics rules as lawyers where there may be a conflict that's waivable under certain circumstances and with certain conditions. If there's a conflict under the mediation standards, it is not waivable. So the fact that these parties were willing to consent was in here intentionally. And that's probably why some of you thought that the mediator could mediate this matter. So this is a conflict because the mediator had substantive conversations with one of the parties concerning the subject of the dispute. And so that's a conflict. The mediator cannot serve as the mediator, even if everybody under the sun says it's not a problem.
Colleen, we have a question. Recognizing the standards apply to mediators anytime they are mediating, regardless of whether it is part of a court-related program, should we define mediation? What differentiates mediation from a facilitated discussion that doesn't result in any kind of enforceable agreement? For instance, the resolution of an internal dispute within various departments of an organization.
I'm going to hope that Tara can weigh in because I don't have the screen. I don't have enough screens. And what I want to do is go back to the standards and see how the standards define when they apply. And I'm hoping that Tara either has that in her brain or a screen that can do that.
So I'm going to give a quick answer because it's a great question and we could spend hours talking about it. So I'm going to give you kind of a basic quick jump in. And then if anybody has questions or if you all want to vet this out later, by all means, give me a call or email me. But the answer is it can be whatever you define it as. So typically when you are communicating with a group to conduct work for them, you're going to call it something. If you call it a mediation, the mediation rules, or I'm sorry, the mediation standards are going to apply. If you call it a facilitation or neutral evaluation, then you're kind of putting yourself in a different category. So if you are communicating with a group of people and they say, hey, we want you to mediate this matter, and you say, yeah, great, I'd love to conduct a mediation for you, then the standards are going to apply. Hopefully that kind of gives you a basic answer, and we'll let Colleen get back into this. And then absolutely reach out to me with any questions you have on that one in the future. It's a great question.
Thanks. All right. Next one, because conflicts and disclosures seem to come up a lot, so we'll cover a few of them. Mediator is asked to serve as a party selected mediator in X versus Y and Z. Previously, Z inquired of mediator's attorney about scheduling a legal consultation for this exact lawsuit. At that time, mediator attorney declined to schedule any consultation, declined the representation, and never had any substantive conversations with Z. May mediator mediate this matter? So now we're up to our second poll, and we're looking for a yes or no on the conflict question of may the mediator mediate this matter?
All right, I know you all can see this because I'm starting to get responses quick. I love it. Click on the buttons if you can. If your technology is being difficult, unfortunately, it is what it is. Just keep the answer in your mind and we'll run through these pretty quick. I'm going to give you about 30 more seconds to respond before I close the poll. All right, folks, last chance. I'm going to close it. And we got a great question. Unfortunately, the way WebEx works, I'm not sure why. We cannot, only one presenter can do this at a time. So the ability to keep the question on the screen while we run the poll is impossible. I'm not sure you would think with today's technology they would have a fix for this. And after doing some research on the internet, it turns out I'm not the only one frustrated by this. It's a very common thing. So what I would love, what we can do is Colleen can repeat the question a couple of times for you if you just bear with us, but unfortunately we can only do one at a time. All right. So we've got the poll. Hopefully you all can see the results. Amy, can you see it? Or not Amy, sorry, Colleen.
Yes is 139 and no is 19.
Perfect.
Okay, great. And then I have to reshare my screen and click a button each time. So the answer is yes. So most of you got this one right. The mediator may mediate the matter. There is no conflict of interest under Standard 7. There was no substantive conversation. And no disclosure is required because there was no substantive conversation nor any relationship formed. So we'll talk more in the next one about disclosures.
Colleen, we have another question.
Okay.
If you're an attorney, we're always an attorney in our interactions. How does that apply to mediator standards?
So I'm going to jump in on this one. It's a great question. So as an attorney, you're always an attorney, but you switch hats when you move to mediator. So when you're a mediator, the mediator rules are going to apply if you're doing a court order mediation. If you're just mediating and you're certified by the DRC, then the standards are always going to apply to any mediation that you conduct. But if you're an attorney, and the DRC doesn't have any jurisdiction over you at that point. So the DRC is put together by statute. So we have enabling legislation that allows us to operate the way that we do to regulate and certify mediators, but that limits or puts boundaries on our jurisdiction and what we can and cannot do. Hopefully that answers the questions. I haven't read them in the chat box.
All right, more conflicts and disclosures, communication challenges. So while the mediator was a shareholder of Firm 1, mediator's law partner represented Party A, adverse to Party B, in a Superior Court action involving a dispute about a family LLC and real property at the beach, which we'll call Case 1. Mediator then left Firm 1 and later was asked to mediate Case 2. Case 2 is pending in a different county with a different case caption than Case 1. Case 2 involves Party A as a party and the wife of Party B, although not Party B. Case 2 involves real property that is different from Case 1. Mediator has confirmed with former partner that partner in the law firm did not advise or counsel Party A as to Case 2. In fact, other counsel represents Party A in Case 2. May the mediator mediate Case 2? So Tara's going to put the poll up, and I will try to reiterate the facts while she's doing that.
Right, and I'm going to leave this on the screen just for another minute to let everybody absorb it. It's kind of complicated.
Sure. Yeah.
All right, guys, I'm going to make it disappear.
So you've got the same Party A in both matters, different other parties, different real property, different case caption, different county, and former law partner represented Party A in the unrelated matter. Can the mediator, but specifically not in the second matter, can the mediator mediate the second matter?
All right, folks, you should be able to see your poll. I'm going to give you about a minute to respond. Colleen, you want to read those facts over again one more time while people are considering?
Sure. So law firm where mediator is represents Party A against Party B in Case 1 at the beach. Mediator leaves that law firm and then is subsequently asked to mediate Case 2 involving Party A versus a different party in a different county with a different piece of property, not at the beach. Law firm confirms that they never advised or counseled Party A about case number 2. May mediator mediate case number 2?
All right, I'm closing the poll. It's going to take a few seconds to get all the answers in. Got a 5-second countdown. Thanks for being patient, folks. Gotta love technology. All right, we got the results. Here we go. Colleen, can you see them?
Yeah. 47 people said yes, 31 said no, 81 said yes with disclosures and assuming no objections, and 49 of you either don't have the ability to vote or are not weighing in on this one. Got it. It's a pretty interesting split there. Share my screen. All right. The answer is yes, with disclosure and assuming no objection. Of course, if you don't feel comfortable, if you feel like this is too close for comfort, you can always decline. But if you want to mediate this case, there is no conflict of interest under Standard 7C because there was no advising, counseling, or representing of Party A in case 2. And it's not an action closely related to the dispute, preceding the issue in dispute, or an outgrowth of the dispute. It is a separate action, separate piece of real property, and the parties are different. Now, that being said, just because there is no conflict doesn't mean your analysis always stops there. So step 2 is the disclosure piece. Because there is a known relationship with a party or a party's counsel that may affect or give the appearance of affecting the mediator's impartiality, a disclosure would be required in this scenario in order to proceed as the mediator. You have to be really extra careful now, to Kathan's question or Kathan's point about the fact that we are still lawyers, even though we're wearing our mediator hat, we still have our ethical responsibilities as lawyers. So in making the disclosure, we have to be careful not to violate any attorney-client privilege of Party A. So one way to deal with that is you could get express permission from Party A to disclose that the law firm had previously represented Party A, or you could say that the mediator previously worked with Party A and leave it at that. If anybody objects, then the mediator may not mediate the matter. Or if for any reason the mediator thinks that he or she cannot serve impartially, then the mediator needs to decline. So on the disclosure piece and the impartiality piece, you're looking at standard 2 of the standards, and then in the Superior Court rules, you're also looking at Rule 6B2 that requires the mediator to advise all participants of any circumstances bearing on possible bias, prejudice, or partiality. That rule and the standard do not require any waiver. However, if after disclosure the parties do not make an objection, it is a best practice to get a verification from the parties that the mediator has disclosed the relationship and that there is no objection. All right, next one. There are 2 lawsuits, Party Z versus Party A, Party Y versus Party A. Both Y and Z have filed similar actions against A. Mediator was designated to mediate for Party Z versus A, but was asked by all parties and attorneys to consolidate the 2 matters. Mediator did so, consolidated the matters, and then mediated both of those matters where A was the common defendant. 6 months later, Party X, so not involved in any of the 2 lawsuits, asks mediator, who's also an attorney, to represent them against Party A. May mediator represent, so now we're asking, may mediator represent as a lawyer Party X against Party A?
All right, this is a complicated one, folks. It's a fun one though, so give it a read while I start to pull it off the screen. I'm gonna pull it in about 5 seconds.
No, it's this question's separate from the prior question. If there was a question in the chat, is this the same one? This is a separate question.
All right, folks, so I've got the poll open. I'm going to give you about a minute. And I do want to point out that we had a great comment that I received that talks about the state bar has a rule that addresses being a lawyer mediator and reporting behavior. It's rule 8.3. And it's definitely something you all should be aware of. If you're not already aware of it, I would absolutely recommend you give it a read. And then I also want you to know that our standards allow for that exception under it's standard 3D8, which talks about if a mediator is a lawyer licensed in the North Carolina State Bar and another lawyer makes statements or engages in conduct that is reportable, then the mediator shall report the statement or the conduct either to the State Bar or the organization having jurisdiction, and that is in accordance with 8.3E of the North Carolina Rules of Professional Conduct. Not that we would ever experience a situation like this, because we all know that people who are licensed by the State Bar or that are DRC mediators, we are all amazing and would never engage in such conduct. So, but it's a great point, and I appreciate Ann Anderson for pointing that out. All right, so it looks like we've got a pretty good list of responses. I'm going to go ahead and close the poll. Actually, I'll leave it open and let Colleen read through that scenario one more time, just so you all know what you're answering.
All right, so 2 consolidated matters for plaintiffs are Y and Z. Common defendant A. Mediator mediates the 2 consolidated matters. 6 months later, party X comes to mediator who's an attorney and says, hey, I want you to represent me legally against party A. May the mediator become the lawyer for party X against party A?
All right, I'm closing the poll. It's going to take 20 seconds to wind down. And I'll let you know that Jackie Claire just jumped in and said that they will be discussing 8.3 in detail during their presentation. So hopefully we'll get a lot more information on that. Y'all are giving us great questions to deal with. I appreciate it so much. All right, looks like we are good. I'm going to share the results. Here we go, folks.
18 of you said yes, 95 of you said no, 36 of you said smells fishy, and 62 of you declined to answer. It's a good breakdown. All right, let me share. Technically, the mediator may represent X against A because it would not violate standard 7 because X was not a party to the mediation. However, many of you noticed that it smelled fishy. It's awfully close for comfort, and it could lead to some motion practice by perhaps the lawyer for party A to maybe disqualify the mediator or just make a bunch of waves that the mediator may not want to deal with or be involved with. So technically, because party X was not a party to the mediation, it would not be prohibited under the mediation rules. But many of you have identified that this would be something that you would run from.
Colleen, there's a question. Would disclosure be an issue with this one? If yes, is answer.
So this is, the proposal was that party X was hiring the mediator as a lawyer, not as a mediator. So I don't think that the mediation rules requiring disclosure would be at play. Do you think so, Tara?
No, I think you're correct, Colleen.
Moreover, I think not only is disclosure not required, but then you have to remember your duty of confidentiality, and you cannot communicate to a non-participant about a mediation. So I don't think that lawyer / mediator can say anything about the prior two consolidated cases. What do you think, Tara?
No, I agree. I think you're spot on. I mean, this is a scenario that, you might be able to twist through. But I would say 99% of the time, it's probably just not a good idea to step in. I see in the chat, there's some great points coming up of potentially there might be a way of using the information to aid in the new lawsuit. But then again, I think that as soon as you open yourself up to taking on a case where you have information that would either hurt or help the case, I think that gets a little messy. And it's the smell test. If it smells funny, just step away from it. It's not worth it. Sometimes it's not worth inviting a complaint that's going to land on your desk and cause stress, even if there's no basis to that complaint.
All right, so moving on to private consultation and when you can consult privately with parties, and the differences under the Superior Court rules versus the Family Financial rules. So the Superior Court rules, Rule 6A2, says a mediator may communicate privately with any participant prior to and during the mediated settlement conference. The fact that private communications have occurred with a participant shall be disclosed to all other participants at the beginning of the conference. So under the Superior Court rules, you may communicate privately with a participant in advance of mediation. You just need to disclose it to all participants at the beginning of the mediation conference. The Family Financial rules, as you know, are different. It is the same rule, 6A2, but under the Family Financial rules, only during the mediated, well, I stated that wrong. During the mediated settlement conference, the mediator may communicate privately with any participant. Before or outside of the conference, the mediator may not have ex parte communication with any counsel or party regarding any aspect of the proceeding except about scheduling matters. The mediator may so engage with consent of the parties to assist settlement negotiations. So this would be something where you could get consent of all the parties to engage in ex parte communications beyond just the scheduling matters. But this is one of the important distinctions, particularly for someone like me who was certified in Superior Court and learned those rules before Family Financial. It's important to note this important distinction between the two rules on private consultation. Interpreters and the use of interpreters. This is, I think, increasingly coming up. Our esteemed colleague Steve Dunn just wrote a really good blog post about it that went out in the dispute resolution section on the NCBA. I would commend you to Advisory Opinion 32 and Standard 4. The mediator is in control of the mediation process and also needs to ensure that the parties understand the role of the mediator and the process of mediation. And so if an interpreter can aid in that, then that is allowed. So the mediator has the authority to allow a third party to attend the mediation, whether that third party is an interpreter or not. The Administrative Office of the Court has a list of trained and qualified language interpreters. Unfortunately, the AOC does not provide them free of charge for mediated settlement conferences. So the mediator may permit a family member or a friend to attend and serve as an interpreter, but the mediator has no duty to find a qualified interpreter, nor any duty to pay for that interpreter. And then best practices listed in Advisory Opinion 32 indicate that the mediator should clarify that the interpreter will relate as completely as possible all that is said during the conference and not just a summary, and should encourage the interpreter not to engage in conversation with a party separate and apart from the specific statements made and or questions asked. The advisory opinion goes on to address what language any settlement document should be in this instance that the advisory opinion was addressing. It was two pro se parties. One was an English speaker and one was a non-English speaker. So we'll get into it in a minute, but there was a mediation summary consistent with the rules for when you have two pro se parties. And the advisory opinion recommends that that summary be drafted in English. And then also the advisory opinion proposes sample language to go at the bottom of that summary to indicate that the summary was drafted in English, read to the parties by the mediator in English, interpreted by blank, so whoever interpreted it, for blank, the party, the non-English speaking party, in the following language, so that there is some record of that.
Colleen, I'm going to jump in real quick because we had a little bit of chatting going on while you were going through this. We have some questions about the communication of ex parte communication with Family Financial and what mediators can do to help pro se parties. This is a tricky one because the standards do not allow mediators to provide legal advice. So while the majority of our mediators are in fact attorneys, and you know what needs to be produced and you know what needs to be shared and what needs to be discussed, you have to be very careful not to cross that line and provide any kind of legal advice, which the DRC has declined to define specifically at this time. What I encourage you to do if you are dealing with pro se parties and the pro se party becomes difficult, or they're asking you questions, or they're trying to communicate with you ex parte, send them to our office. We are happy to walk people through, explain to them. We'll take the time to work with them where you all aren't, necessarily available or have the time to deal with pro se parties. And then, as Keitha mentioned, the commission has approved a form, which is kind of a pro se guide to family financial matters that will kind of indicate what items could and should potentially be brought to a mediation to be discussed during the mediation. And it is kind of just a way to inform pro se parties as to what will be discussed at the mediation. But please keep in mind, folks, you can't give any kind of legal advice. You can point out rules, statutes, websites. You can lead them to information, but you cannot apply their facts to the information that you're providing. Thank you.
Thanks. All right. Next poll is party or counsel changes. So this scenario is mediator mediated case A and recessed it with a date to reconvene. Between recess and reconvening, the lawyers for the parties in case A tell the mediator that it might be possible to find a resolution if they then include some parties, some non-parties to case A who are represented by lawyer B who did not participate in day one of mediation of case A. So they basically say, we want to reconvene and we want to invite somebody else who's not a party to come join our party, our mediation party, and bring their lawyer with them. Under standard 3, so this is going to be a poll in a minute, may the mediator disclose anything from day one of mediation of case A to lawyer B?
All right, I'm going to go ahead and pull it off screen, folks. Colleen, you want to read through the question again while I put this up?
Sure. Mediator mediates, excuse me, and recesses the case. Before reconvening, everybody agrees, let's bring a non-party in that may be able to help us resolve this case because there was a parallel action and other issues. And so now a non-party to the mediation and that non-party's lawyer is going to come to the reconvened mediation. May the mediator disclose anything from day one of the mediation to lawyer B?
All right, so I'm going to leave it up for about 20 more seconds. Looks like the answers are coming in fast. Okay, I closed the poll. It's got about 15 seconds for WebEx to catch up with all the answers that came in. All right, here we go, folks.
103 say yes with consent. 49 say no. 62 are still not playing with us. Okay. Back to screen share. The answer is no. So be careful on this one. Even with consent, the answer is no, right? So remember, I don't remember if it's in a different advisory opinion, but I remember from my training this sticking out in my mind that parties were moving to enforce some settlement agreement. Everybody agreed mediator could come testify in court, mediator testified, and that was a violation, right? So the fact that everybody agrees is not the linchpin here. When it comes to standard 3 confidentiality, the mediator may not disclose any information with any non-participants to the mediation. So what the heck do we do with that? The other lawyers who participated in day one can disclose whatever they choose to disclose to get the new lawyer up to speed. And then I've got another question here of, okay, let's say the new lawyer gets up to speed, and then at some point during day 2, the mediator needs to say something to revisit something prior from day 1 while lawyer B and clients are present. What should the mediator do? The mediator can speak privately with the participants from day 1, pull them in the hallway, go in a separate breakout room. When I personally have had these types of issues come up before, I am very apologetic, and I usually just throw it all on the DRC and say, they've tied my hands. I'm so sorry. I understand the rule for the reason the application can be kind of clunky, but here's how we're going to get around it. You know, other lawyer, you get to talk more now, which usually isn't a problem.
Okay, Colleen, we have another question.
Yes.
I actually have a variation of these one in a case now. Lawsuit originally involved only party A and party B. Mediation conducted, recessed. Party C then got involved and party A has been dismissed. So the relevant players are now only party B and party C. Part 2 of the mediation is scheduled soon, involving only B and C. What to do?
And this is court ordered?
They don't say that.
Yes.
So somebody responded and said, schedule a short mediation session with all parties and then have the lawyers talk to each other about what happened. What do you think about that, Tara and Colleen?
Yeah, I mean, the lawyers, if they so choose, can bring the other one up to speed.
So, and then I just received, is there no distinction between testimony from a mediator and a mediator sharing info from prior mediation when new party has joined the mediation?
You cut out a little bit on that question. Would you say it again for me, please?
Is there no distinction between testimony from a mediator and a mediator sharing info from prior mediation when new party has joined the mediation? And one of our trainers responded that said the new mediation should be treated as a separate mediation and confidentiality stands between them.
I think the biggest issue here is that what was said at the first mediation needs to stay within the confines of that original mediation, at least as far as the mediator goes. Anything that occurs regarding a settlement conference in the future, again, you're back in you're mediating again, but the mediator cannot disclose information from the previous session. So you're kind of starting from scratch and going over. The parties can certainly disclose anything that was discussed previously, but that's not the mediator's job. That would be the attorney's or the party's job to share that with the new participant coming in. And John, I'm not quite sure I understand your question about a distinction between testimony from a mediator and a mediator sharing. Testimony, Colleen, do you understand exactly what he's asking? I'm having trouble.
Well, we're gonna, if we have time, I'm not sure we're gonna get there, but if the mediator receives a subpoena to testify, the mediator has to object based upon confidentiality grounds. And then if the judge ultimately orders the mediator to speak versus going to jail, I think the DRC says the mediator can speak and doesn't have to go to jail, right?
Right. No jail.
But the distinction I want to make is also in the slides, and also I'll skip it when I get there. If it is the same party and they just have new counsel, then with the consent of all the parties, the mediator can get the new counsel up to speed about settlement discussions. But if the party changes, or if it's a different party, or if it's a non-participant that just is welcome to the stage, then the mediator may not share information with that person.
Okay, so we have another question. What happens if the mediator thinks the lawyers are not telling the new party the truth about what happened prior?
I'll hit on this one, yeah. So if you think something hinky's going on, then it's your job to straighten it out or to recess or impasse the mediation. Especially if you know that information is basically being twisted to fit into a box that it's not going to fit into. So your job as the mediator is to pull the lawyer out who's giving the false information and remind them of the importance of mediation and being a good attorney, etc. What goes on with that? That's kind of a great question, because if you're failing to disclose information that needs to be disclosed or is required by law, then you cannot continue the mediation if you know that rules are being violated. If they're simply kind of skating over and giving half the information that is beneficial and the other half would be beneficial, but they're not violating any rules, then I think it's a judgment call as to whether you move forward or not. Maureen, we got more questions. What do you have for us?
Yes, I do.
Great.
Can the mediator tell the attorneys that they can share from the previous mediation, but the mediator cannot? Okay. Can the mediator tell the attorneys that they can share from the previous mediation?
Colleen?
I think the question, if I'm understanding the question correctly, the mediator can tell the lawyers, my hands are tied, but you all can bring the new lawyer up to speed. Is that the question?
I think so. Correct.
Yeah. Yeah. The mediator can say, I mean, here's what I do. I am really sorry. I am really frustrated by the fact that the efficiency of it would mean that I should be able to just bring everybody up to speed. But that's not what the rules are, because confidentiality is so important. So you other lawyers, would you please help me out and bring so-and-so up to speed?
We actually have an advisory opinion that talks about, and forgive me, I don't know the number off the top of my head. We have an advisory opinion that talks about at the beginning of the mediation, it's important to let the parties know that you as the mediator are bound by confidentiality, and you are to let the parties know they however are not bound by confidentiality. So it is something we encourage you share with the parties to let them know that they can speak freely. And if they want the information to be confidential, they need to get into their own contract to do so. Real quick, I'm going to jump in with a great question from Nicole that talks about receiving a subpoena and objecting. Anytime anybody receives a subpoena, I encourage you to call me immediately. I'm batting 1,000 for getting these things withdrawn. Not to say that I'll continue with that, but hopefully I will. Typically, the person who is issuing the subpoena is not familiar with the rules, and they don't realize that it's going to get shot down. So anytime you receive an affidavit or a subpoena, absolutely give me a call. There are very limited circumstances where you can provide information under both circumstances, or under both a subpoena and or an affidavit. But it's not something I want you to necessarily stress over. I just want you to know that if you do receive one, call us, we'll work it out. All right, Colleen, back to you.
All right, so this is the slide I was getting into a minute ago, that if it's the same party, they just have a new lawyer, then with the permission of all the parties, the mediator may get the new lawyer up to speed for the purpose of advancing settlement discussions, and mediator needs to be careful to ensure clear and accurate recall and must present the information in an unbiased manner. And that's standards 3D7. Confidentiality questions. Employer hires a mediator to mediate a workplace feud between 3 employees. Employer does not attend the mediation. Mediator mediates the case and provides a written report of the result to the employer. We're going to skip the poll in the interest of time. Does this violate standard 3 confidentiality? Yes. This is a violation of the mediator's duty of confidentiality. The mediator is only allowed to disclose information to the participants of a mediated settlement conference or the court by way of a report of mediator. Here, the employer is not the court, and the mediator may not provide a statement reporting the outcome of the case to the employer. All right, multi-day mediations. Tara says that she gets questions on these. So the mediator is in charge of the mediation process. So the mediator gets to decide when to impasse and when to hold it open. If it's recessed and the reconvening date and time are determined and set and shared prior to that recess, then no additional notification is required. If a party refuses to resume a scheduled session, the mediator should impasse the matter. And under the rules, payment is due at the conclusion of the mediated settlement conference. So if you are court appointed, the rules say the fee is due at the conclusion of the conference. So that would be at the end and when you file your report. If you want to contract around otherwise and say that payment is due at the conclusion of each session, then as long as you're party selected and you want to contract around that, you can do that. However, in any of those scenarios, if the parties do not pay, that cannot be the basis for the mediator to delay the mediation process to go on to the next session. All right, finalizing agreement. Do you have an agreement to agree, or do you have a final agreement? So be mindful of that. I struggle with this personally because I'm supposed to take my lawyer hat off, right? And to me, the determination of whether you have an agreement to agree or a final agreement is a legal determination. But the way that I have worked on that is just sort of asking questions, right? Instead of stating my opinion, I say, you know, do you think this is a final agreement, or do you think that it leaves anything open as an agreement to agree, and see what happens from there. The terms need to be reduced to writing, and all parties or their designee, we'll talk about designees in a minute, and their counsel sign it. Electronic is okay with agreement. Remember, in family financial, if it's not going to be incorporated into a court order, it also needs to be notarized. So what do we mean about designees? In a relatively recent rule change, Rule 4C was amended to say that a designee may sign the agreement on behalf of a party only if the party does not attend the mediated settlement conference and the party provides the mediator with a written verification that the designee is authorized to sign the agreement on the party's behalf. Recall that that was in large part prompted by a Court of Appeals opinion finding that the party's counsel signing the agreement was not sufficient to bind the party. And then another thing on finalizing the agreement, remember, a mediator may not draft the settlement documents for the parties. Give the attorneys the AOC form and tell them, again, throw the DRC under the bus, tell them that they're so mean they won't let you do the drafting. And see advisory opinions 28 and 31. Differences with pro se parties, if all parties are pro se, so you don't have any lawyers involved, then an unsigned, non-binding mediation summary of the understandings reached may be provided. It is not a written agreement. That is something that the mediator may be the scrivener of. The AOC form is AOC DR 18, and I just copied the relevant portions of it. And so the parties will see, and you will see, that it specifically says it's a summary. We can't conclude with a written agreement, and it's not binding, and they can take it to an attorney or they can take it to the court. So that's a difference with all pro se parties.
All right, Colleen, I'm going to cut you off. It's 10 o'clock.
Sounds good.
So everybody, I want you to kind of clap in the air so she can scroll through and see everybody's appreciation. Colleen did a great job. We're very grateful to have her